Greetings everyone. Ça me fait incroyablement plaisir d'ouvrir cette session en l'honneur de mon collègue et ami René Provost, ancien directeur du Centre sur le droit de la personne et le pluralisme juridique, et qui a accouché il y a quelques semaines à peine de ce magnifique ouvrage. Long in the making, I think, as your sons reminded you a few times. But definitely worth the wait. It's an extensive, it's a rather long book, but worth every page of a read. And where the center is delighted to host this event, which we imagine as a kind of fireside chat. So in making it as informal as possible. Greetings, of course, to all of you who. Because of a pandemic and other reasons can't be in person with us. We know you're there. We will be attentive to your questions. Don't hesitate to ask them using Zoom's chat function, which I'm sure by now everyone is very familiar with. And thanks, of course, to our in-person guests. So, René, rebel courts, the administration of justice by armed insurgents. I've obviously read it in preparation for this event. I enjoyed it hugely. For those who haven't had a chance to read it yet, I just want to highlight maybe a few of its distinguishing features. I think perhaps the first that struck me is it's a book that quite uniquely for a law book really straddles the doctrinal, which is quite familiar for lawyers, but also the empirical and the theoretical. And to have all three in the same book is really a bit of a tour de force and really something that, one would expect, and perhaps particularly in this sort of area, more of in international law. And certainly reading the book, I mean, it strikes me that a pure doctrinal treatment or a pure theoretical treatment just wouldn't have done it, right? Because we actually want to know about these rebel courts. We don't want to know just about the idea of rebel courts as, imagined in Geneva or elsewhere. We want people who've actually met those involved. And and René will speak to this, but I want to stress how difficult getting that information must have been, how time consuming, how even dangerous, quite unusually for law research. Which often, is done from the safety of the office. So I wanted to maybe emphasize a couple of themes to start with that are connected to this center and this faculty and what we've been trying to do for a few years. So one thing that struck me is it's a book that's both rooted and nomadic. So it's rooted, I think, in your presence here at the faculty and the fact that you've been one of the leading exponents of what some of the intuitions of legal pluralism might mean for human rights and international law, and in the work of the faculty at large. You cite Rod MacDonald, for example, and many others. But it's also traveling. So you've taken some of these intuitions which we know are fairly global, but part of which were born in Quebec and then sort of in this faculty, and you've taken them to the world as part of a sort of complex encounter with these actors as part of your search. And of course, the whole book is immersed in a critique of the centrality of the state to our understandings of the law, which has been a kind of faculty obsession for a long time. I also know that this is something you frequently told me, you're a big believer in teaching international humanitarian law, in particular, not because people will necessarily go on to work for the Red Cross and specialize in it, but because it's a highly abnormal branch of the law. And because it's so highly abnormal, it has incredible lessons to yield for our understanding of a contrario, what might be normal law, and problematizing what that normal law is. And so I think that image of teaching international humanitarian law as part of a curriculum, even though Canada isn't at war and most people won't use it directly, but as a kind of intellectual exercise, I think comes very close to what this book is about. Thinking about non-state law in its exceptionality, in its idiosyncrasies, as a way of thinking about state law and justice and what they might be. I'll make one last introductory comment, I think, to go back to the methodology of the book. So there's really a kind of constant pincer movement that's almost sort of visible as you kind of, go through the book, from international law to actual practices, and sort of international law's implicit idea of what these practices are, and from actual practices to international law. So the practice speaks back to international law and to those categories, invests them with meaning, uses them, but also transforms them in the process. So I call that la méthode Provost. I think this is, really your hallmark, and as I think this is really sufficiently exceptional to be underlined. I want to start with a fairly simple question, but I often ask my graduate students when I'm trying to get to the heart of their project. I say, but really, what is the story, the kind of the initial story that was the impetus for this project? What got you started? What really teached you? And I understand that there's a bit of a thing happening in a suburb of Stockholm at one point.
Okay, well, thank you, Fred, and thank you to the center. Thank you for reading the book. You might be the first person to actually read the book, apart from me. Hopefully there'll be a few more people doing that as well. And thank you for sharing your first impressions of the book. I gave a copy to my mother, and her first impression was that it was printed really small and it was really long. But I think that I agree with all these impressions, and in particular, perhaps with the idea of a pedagogical dimension to the project, which I don't think I had in mind, but it is really still part of thinking about law and why we should care about law in general, and how war is a place where law is under the most stress, perhaps that happens anywhere, for lack of institutions and uncertainty of norms and priorities that don't align with the values that normally inform our laws. And so I think that is true, that I'm perhaps trying to teach something about the nature of law that I don't necessarily make explicit, except perhaps in the conclusion when I kind of expand and become a bit more poetic, perhaps about what I'm trying to do. Now, to go back to your question, there is one story that it's not the origins story, but it is one story that that I became aware of about midway through the project, and which really kind of emerged, and I thought, oh my God, this is wow, where did this come from? It's exactly what I'm talking about. And this is the story of Omar Sakan. And Omar Sakan was a refugee in Sweden, a refugee from Syria, who had been granted refugee status in 2012 after fleeing the war, and was living in Stockholm. And a video was posted by the New York Times showing a group of men in Syria shooting and killing another group of men bound, lying on the ground before them. And someone in Stockholm recognized Omar Sakan as one of the shooters killing a man on the ground. And he was arrested and accused of murder. And his defense was to acknowledge that indeed it was him on the video, but that he was carrying out a capital sentence pronounced by a court of the Free Syrian Army against a number of soldiers. And Sakan's story is quite remarkable in that, he was an electrician and joined the protests against the Assad regime in Syria. He eventually had to flee Syria because of his involvement, but decided that he had to return and fight, and joined one group that's linked to the Free Syrian Army in northern Syria. And only on the fourth day of his presence back in Syria and his activities as an armed combatant, he was involved in an attack on a government post in which a number of government soldiers were detained. And the next day, while he was away in another village, having been detailed to participate in the official burial of one of the fighters that had been killed, a court was convened, composed of former judges of the Syrian regime who had defected to the opposition, to judge these 9 soldiers and hear evidence. They heard witnesses, and there was physical evidence from cell phones that had been recovered on these government soldiers. And they were identified by a number of civilians as having run a checkpoint where they would abuse people, beat them, and sexually assault women. And some of the sexual violence was captured on their own cell phones. And so when Sakan came back, he was told, well, these 7 of the 9 have been convicted. And applying the Syrian penal code, the death penalty was the crime applied by Syrian courts for a crime like that. And so he was told that his unit, his section was going to be the firing squad. And this is what the movie showed. And so his defense simply was that he was a soldier, and in a court of his group during his absence had condemned these individuals under actually the law of the state as applicable at the time, and that he had merely carried out the lawful order of a regularly constituted non-state court.
Okay, so that's fascinating, and it resembles it brings to mind also Second World War cases, etc., where the question arose, including in relation to state courts, right? Whether these orders were legal or not, and maybe that's something we could go back to. But I want maybe to highlight how much of a puzzle that whole situation creates for international lawyers, right? Because we're used to thinking about states' legal systems, right? And I think there's whether it's for courts, whether it's concepts such as the rule of law, there's tremendous reluctance to, initially at least, to fully take seriously the idea that these rebel courts might be, anything else than a kind of, jungle folklore, right? And so if this is what you're up against, I think initially is just sort of conceptually the fact that the discipline is really set in its ways to kind of not see this as part of the legal phenomenon. So one of the things that you do, I think, sort of early on with kind of the first chapter is imagining what a non-state version of a number of well-trodden state concepts might look like. And you do that in relation to the rule of law, to courts. Can you explain, maybe give us a sense of the challenge of doing that and why you felt it was so necessary to kind of start off with that?
Right. Well, those of us who have the blessing of the curse of being trained in the law are aligned with the state from the first day of law school, and our late and lamented colleague Walt MacDonald used to decry our lawyers and law professors' obsession with courts, and he tried to get us less interested in courts. But the fact remains that in thinking about law, we always connect it to the state automatically, as it were. And I think that this is a vision of law that is propagated in society as a whole, so that people are socialized even as children and or things that parents tell you as connecting the law to the state. So we have kind of a narrowing of vision of law to reduce it to law connected to the state, at least in places like Canada. In other parts of the world, parents might educate their children differently, and they may or may not label these other regimes or normative orders as law, and they might say, well, you know, arranged marriage or custom rather than a law, but they may be binding just as much regardless of the label. So Western law and with it, to a very large extent, public international law, which is kind of my field of reference for this, is very much aligned with this state-centric idea of the law, which led, to go back for just a moment to Omar Sakhan, which led the Stockholm District Court to convict Omar Sakhan. And he is sitting now in a high security jail in Sweden, serving a life sentence for murder. And so it's important to remember that there are real life consequences to these questions for all sorts of people. And Sakhan certainly is one of them. So a first idea is to interrogate this relationship between law and the state, because it's obvious that if we have a narrow understanding of the connection and we accept the claim that you know, from Jean Bodin, Thomas Hobbes, and people like that, that really embrace a monopoly of the state in the creation and the administration of law, then it would have been a much shorter book, because all of this is just the variations of illegalities, and and law doesn't become a register that's very interesting or helpful, because there are no distinctions to make. It's all unlawful. And that was, to me, a significant reason to want to challenge this, is because this is, in a way, an abdication by lawyers of what is going on in conflict zones. And we basically remove our ability to try to act on what these armed actors are doing in conflict zones. And what they're doing has quite a bit to do with the administration of justice. And it's always kind of the facts on the ground, as you were saying earlier. It is happening on a daily basis in many parts of the world in ways that really never have attracted that much attention by anybody, really, except the counterinsurgency people working with the militaries to try to, you know, use that against insurgents. But certainly lawyers never were that interested. So an idea like the rule of law, I think, is one that must be looked at with a question as to its necessary connection to the state. And I think that there is, I mean, it's an enormously contested idea, the rule of law. And so in every way that it is used, it is subject to kind of nearly to contestation in nearly every direction. So this is a state of fluidity in which I can easily put myself and argue that the rule of law does speak to certain kinds of expectations of life in society, of relating to others, that can be applied to relationships with governance entities other than the state, including non-state armed groups. And what armed groups are doing in conflict zones, I think, can match some attributes of the rule of law that will not be the same attributes that we look for in the rule of law at the hands of states, or, for example, the rule of law at the hands of the United Nations, when it sends peacekeepers to Haiti or the Democratic Republic of Congo, and it is more or less the government in those places, well, I mean, there should be an expectation that the UN is abiding by the rule of law. On the other hand, it's not a state. And so there will be differences. And the same goes for the FARC in Colombia or the Tamil Tigers in Sri Lanka.
No, I mean, in fact, of course, we're very familiar with, ought to be familiar with the notion that the rule of law, even among states, differs, very significantly, right? L'état de droit and rule of law are actually, kind of faux amis, right? So in a sense, that pluralism has always been built into the system. Once you accept that, the idea that other entities could be the repositories of their own concepts of the rule of law is easier to sort of conceptualize. And there's something that I thought was really interesting about what you said, but perhaps I know has always been close to your heart, but isn't that clear in the book? So one way of looking at the book is it's about looking at situations of armed conflict, situations that are exceptional as opposed to peace. Another way of looking at the book is it's by looking beyond the West and beyond sort of Western sort of modern liberal legality to alternative modes of conceptualizing justice, maybe not the rule of law, that's too tainted, but justice, courts, etc. That typically remain invisible because of all the biases that we know that are built into international law, but which in some places are actually the norm, right? I mean, the exception is that you have a kind of unifying, centralizing state that is the only origin of the law. So, there's a really interesting connection in that book with some of your other work in sort of cultural anthropology and sort of and legal pluralism more generally. I note in passing that the non-state actors, the rebel groups themselves, often fall into the trap, right, of wanting to be plus étatique que l'État, right? Daesh being the sort of the classic example, but there is also that kind of parodying of the state, which shows how kind of structurally ingrained that is. Now, so in some ways you could have left the book there, right? And you could have said, well, there's something that we could redescribe as the rule of law, if only our concept of rule of law or courts were a little more capacious, etc. But then there's a really interesting twist to the book. I see it as a twist. It's kind of ta-da, it's a ta-da moment. The ta-da moment is you say, well, you would think that this was the furthest thing from, modern legality. But in fact, if you scrutinize international law closely with the right eyes, you see that international law itself, in turn, has a kind of at least ambivalent position towards these rebel courts, and in some ways maybe legitimizes them or calls for them to come into existence. And so I think that's a really interesting plot twist. And but so I want to maybe push one point, right, which is this kind of strange asymmetry that there is between rebel courts and state courts, right? State courts, we know, can be bad, really bad, as in violating every single right, as in being sort of, barely worthy of the name court. But as long as we don't hesitate, I mean, we tend to treat them as courts nonetheless, right? With maybe a few extreme exceptions. But there's a kind of asymmetry in the, it's almost as if rebel courts have to do twice the work, right? And that the threshold for them to be even remotely recognized as courts is higher. It's more than effectivité. It's also a sense that they respect minimum fair standards as a kind of constitutive condition of their being even contemplated as being courts. So what do you make of that, right? I mean, it seems obviously it's totally what one would predict would flow from a Westphalian blueprint, but from a more pragmatic human rights or humanitarian perspective, it doesn't really make a lot of sense.
Right. It's a real page turner, isn't it?
Trying to get promoted. I've got your Amazon statistic there, and 30 books were just sold. So,
so let me bring you back to Omar Saka once more, because there's a profound irony that the Stockholm District Court found some comfort in the fact that the judges sitting in the court of the Free Syrian Army, so the rebel court, had been appointees to the official courts of Syria, and they had defected. And the court there even says that this is for as far as it could say, a condition of legitimacy for rebel courts in general, a claim that I find to be without any foundation. But beyond that, if you stop and think about who we're talking about here, it's like these are judges in the courts of one of the most repressive states on the planet, with a court system that is basically little more than the tool of repression. And this would be a factor of legitimacy for a rebel court is more than a bit ludicrous. And there is a reality that armed conflicts don't tend to happen in places with very strong, independent, and impartial court systems, right? They tend to happen in places with weak rule of law, like Syria, like Afghanistan, and like Colombia. Let me mention as an example of a country with kind of uneven rule of law. So some places like Afghanistan and Syria have sort of very weak rule of law across the board. Other places like Colombia will have very effective and solid judiciaries in cities. But then you go in remote parts of the country, and then the state more or less disappears, and the rule of law becomes truncated, often corrupted, and so there are multiple realities, even within a given country. So, as you say, when we look at courts of states, we basically take for granted that these are courts. And then we might criticize them for behaving in a manner that is not consistent with, fundamental human rights, such as due process guarantees and so on and so forth. But we rarely will question their reality of courts. I think that this is a bit of a blind spot for lawyers, because at some point, courts no longer exercise a function that should be described as judicial. And for me, Hong Kong currently is one situation that provides an example of a transformation of public governance towards a regime where we might wonder at one point whether these are real courts anymore, as various statutes and actions remove the kind of discretions that we associate with the administration of justice. So for rebels, we don't have this presumption that we endow courts as being real courts. And then it begs the question of, what do we mean by court? What is a court? What makes a court as opposed to something else? And the practice of armed groups is really very diverse. So some, like the Tamil Tigers, had very formalized court system, and you were speaking about a tendency of mimicry, right, of armed rebels that mimic the official court. And in the case of the Tamil Tigers, when they took control over the Jaffna Peninsula, the northeast of Sri Lanka, they basically went into the courthouses, they took away the coat of arms of Sri Lanka, and they put the coat of arms of the LTTE, and then a judge sat there wearing a robe, having lawyers also wearing robes. And it took me a while to have the information whether they were wearing wigs. And the answer is no. But there's one detail that I spent a long time finding out about the wigs in the LTTE courts, because to my mind, these are things that matter. These are things that matter in a sort of a narrative sense about what kind of claims are these groups making in creating and operating these institutions. And so the LTTE was making a claim that it was a state, and it was a very powerful claim that was powerfully resisted by the Sri Lankan judiciary. Compare that to the FARC in Colombia, which never really created anything like real courts. And what they did is that they instrumentalized local justice practices, essentially community justice practices, popular assemblies, and they kind of nudged them to behave in the way that they wanted. And the nudging could be, through direct violence and assassination if need be. But often it wasn't necessary, but they created nothing that looked like a court. Does that mean that it's not a court, that the FARC didn't have courts and the LTTE did have courts? And so it requires us to unpack what we mean by court, asking questions that we don't ask in kind of the ordinary consideration of the administration.
So let me push you a bit on this, right? So on one hand, you could say, well, clearly the rituals and the theatrics and the architecture of justice is an important component of justice, but I think we would then hesitate to say that it sums up justice, because you could have all of the status symbols and render something that has nothing to do with justice. You could, on the other hand, be engaging in something that is politically creative, interesting, but that we would hesitate to qualify as justice. I mean, it's politics, it's self-rule, and maybe it's great for other reasons, but it's not quite justice. So I think that kind of brings, I think, this really important question, which I think is at the heart of the book, is where do you put the cursor? And when do you know sort of real justice from mob justice, in a context where, of course, we have to account for the fact that justice can't be the same thing everywhere, right? So there's also that dimension of, maybe the LTTE or the FARC, I mean, that's the whole point, right? They are inventing something, and states have done this, right? With Gachacha and Natua Put, which you mentioned as well. So departures from the Western canon, but lawyers have, sort of international lawyers have often resisted, but I think are kind of invitations to maybe sort of loosen our grip on what counts as justice.
Absolutely. And so why should it matter? And which is a different way of asking, why should armed groups want to do this? And I think it relates to the idea that to call something law is to endow it with legitimacy in itself. So it is a transformative act to label an act the exercise of justice and to invoke standards as legal standards. And in itself, inherently, it transforms the practice and the norm by the mere rhetorical act of labeling them as such. And this is why it's important for these groups to take up the mantle of the administration of justice. It is part and parcel of the insurgency. And so it is not something apart that they do, in addition to fighting with weapons and, they hope to win the war that way. And the administration of justice is just whatever, something they need to do in the meantime. That is not, this is not the way insurgency occurs. Clausewitz famously said that war was the continuation of politics by other means. And war is also the continuation of politics by the same means. And the administration of justice is a very important device through which the insurgency advances. And one fascinating aspect of the research that really kind of took me by surprise is the finding that groups like the Taliban would begin a takeover of a region through the administration of justice. And so they would have people present in an area that was still under military control of the government all the coalition forces and basically start the work of displacing state justice in this area. And it is once they had solidified a presence through the administration of justice that they felt the conditions were right for a military takeover in an area where they would have a foundation already to kind of govern essentially and pacify the area and then, you know, move on. And in many ways, the incredible takeover of Afghanistan by the Taliban last August, to my mind, it was not a surprise. And this is one time I can say, you know, they were talking about, you know, oh, there's, you know, it'll be a couple of years as before they were pulling out, you know, before the Taliban takes over. And this is one rare time where I can truly say that I thought that this was crazy, that the Taliban was going to take over kind of nearly immediately. I don't think I said quite so fast, but it's because they were already pretty much present in all of Afghanistan, even Kabul, through largely invisible governance practices that were largely discounted by the coalition forces and largely discarded by the government as mere illegality in a way that was directly inspired by the vision of law that we were describing earlier, that it's just not law, it's just kind of just unlawful actions. So
fascinating, and I recognize in that, of course, a bit also the humanitarian mindset, right, which is to look at things that are happening on the ground, which may be less than ideal. You know, I mean, war's not supposed to happen; it's been made illegal, but it's there, and you have to regulate the phenomenon and do what you can. And so, you know, which is resisted by historic, you know, by some international lawyers. And I think your project intellectually involves sort of, you know, doing something similar, right? Sort of paying attention to what is actually going on and saying, well, we have a choice. We can ignore it because it doesn't fit the model, or we can try to work with it. Which is also, you know, partly where, you know, the project is interestingly sort of perilous potentially, because as you accompany that, you know, you also potentially legitimize it or suggest ways in which it might be legitimized. So if one way to spin the, you know, an endless Clausewitzian, you know, maxim a little further, right? So one concern might be that justice is actually the continuation of thought by other means, right? And that these rebel courts are sort of totally instrumentalized for warlike and political purposes, which is why I think your book cannot leave them where they are, right? And you need to sort of rationalize their existence within broader frames, and particularly the frame of international law. So yeah, I have a couple of questions for you. So one is maybe first, and I alluded to this already, why is international, like states are obviously dead set against rebel courts, right? No state is, you know, has it in their constitution that, you know, if, you know, rebel courts were to emerge, this is how they should, you know, behave, etc. Right? So it's a complete impossibility. International law is, I think, more pragmatic. I mean, it's committed to the state, but it's also committed to certain humanitarian values. Maybe you can speak to that a little bit. You know, what's international law's skin in this game? And the other question I had, it's a little more specific and a little more technical. So, c'est un peu pour retourner à tes premiers amours, excuse-moi, toujours un peu gênant. So the relationship between humanitarian law and human rights, the object of your thesis and your first book. So you seem to me, as you're looking for framing an international law, to rely quite heavily on international humanitarian law. And it's almost as if, and maybe I'm you know, I'm not quite right here, but it's almost as if human rights are a bit of an afterthought. Your hook fundamentally is that these courts arise in conflict zones that are marked by violence and war, and where international humanitarian law says that, you know, if they are to, you know, to judge people, you know, people have to be judged by regularly constituted courts, right? And that then presents you with a bit of a problem, which is that international humanitarian law's interest in that issue is very narrow, right? It's sort of criminal, essentially. But your rebel courts are, in fact, very ordinary, very, pedestrian. I mean, they do family law and all kinds of private law issues, etc. And so my sense is there's a bit of a humanitarian law bias where, regularly constituted, right, to borrow from Article 3 is kind of borrowed from international humanitarian law, including as it applies to courts that really, as you say, could be dealing with the theft of a cow, right? So in a sense, they're only dealing with the theft of a cow because of the violence of a rebel group that put them there. But the theft of a cow itself is not an international humanitarian law issue, right? It's just totally peripheral. So I wonder whether you couldn't have kind of, done this more through a human rights lens by starting from a kind of basic demand for courts as a sort of as a human rights entitlement, but ultimately maybe has something broader to say about the emergence of these courts that are both exceptional and in some case quite normal and permanent and almost peace-like.
Okay, there was a lot in this comment. Let me just maybe go back to where you started, to violence, and to agree with what you said that, well, the creation of courts by armed groups is violent, but so is law in general. And here I'm always very inspired by Robert Cover's writing about violence and the law and the violence that is inherent in the idea of law. And to which I would add a sense that people in war zones typically are disenfranchised from the legal system, regardless whether we're talking about the state legal system or the legal system of armed groups. So, the discourse that we have on this phenomenon emanates from states who have a central stake in defending their courts. But if we shift away from a perspective grounded in the defense of state interest and take the perspective of individuals, which I think is what human rights law encourages, and humanitarian law to some extent as well. Well, what fundamentally matters is not necessarily who appointed the judge, but rather is this judge fair and administering a set of laws that was known in advance, relatively clear, that could be that could guide behavior, and issuing decisions that are final, that will be respected, and so on and so forth. And the fact that the judge was appointed by a rebel group as opposed to appointed by a government, in both cases, possibly for reasons that are not completely kosher, we might say, doesn't really transform the nature of the decision. We could indeed talk about a human right to courts, although to me that is just really another way of talking about the rule of law. And it is a way of converting that through the lens of individual rights, and perhaps subject to the critique of rights, but in a super heightened fashion about rights as fragmenting interests, connecting that to the rule of law, which is a very collectivizing idea. I think is to me that I see some issues in going that route.
I wanted to follow up on something that you said, I think, which is really crucial, goes to the heart of the book. So the suggestion that the performative element in the law, that who the author of the law is, whether it's state or non-state, matters or should matter less to us than the nature of the norm, whether it's a good norm, whether it's good adjudication, etc. And so that's really interesting, because that's maybe taking us a little further, right? Than a kind of, we should pay attention to these rebel chords to, hey, maybe they're sort of an example of what could be. And, I'm reminded globally, there's obviously a trend towards decentralization, the rise of cities as regulators and creators of constitutional norms, increasing levels of corporate governance, Facebook, right? So is there a possibility that armed groups' legal systems in some case, maybe are experimenting with what governments can't? And I know that in some cases, not all, I'm not thinking of Daesh here, but in some cases, there's experimentation with informal justice, mediation, direct incorporation of international standards, hybridity and diversity of sources of law. In other words, what we've some of us have been suggesting, states should be doing all along, and here we have non-state actors at the forefront. So, is there something even potentially exemplary about rebel courts?
Well, there's always hybridity in justice and in law, whether state law or non-state law. So legal orders always intersect, mutually constitute each other in ways that we tend not to recognize as when we talk about state law, but which for rebel law is often more visible because in some ways it is a moment of creation of a legal system that we rarely get to witness. What is it like to just create a legal system out of the ground? And in the state context, we rarely have that opportunity, even when there is a revolution. There is always some continuity, and I think there is much less so for rebel law. So rebels do experiment, and they do venture in places where the state does not. And one example for it is the regulation of magic or witchcraft, which is something that many rebel groups just take on board as, they regulate, speed on the roads and opening hours of restaurants and, the practice of witchcraft. And in ways that states don't, or at least Western states don't. But this is simply a reflection of the proximity governance that the rebel administration of justice stands for. And this proximity is not necessarily political, but it is often cultural. And the register within which the administration of justice takes place will often be much closer to the cultural reference of the population in general than that of state law. And I think that the Taliban administration of justice in Afghanistan is perhaps the best example of that, where the Taliban administered justice on the basis of Sharia mixed in with Pashtun customs. And this was basically what people knew, as opposed to the law of the state that nobody knew. Indeed, even the judges, the majority of whom did not have any kind of legal training, and also had no access to any statutes. They didn't have access to the decisions of the Afghan Supreme Court. So, they were speaking about something that really had no connection to what the local people were familiar with.
Yeah, fascinating. I'm reminded that we have another 5 minutes before we take questions, both from the room and from our online participants. So please, if you have questions, get them ready, and we'll make sure to ask as many of them as possible in the last half hour. So this is, obviously fascinating, and it takes us a long way from international law's own traditional criteria of validity, which are very top down, right? I mean, does it conform to human rights or not? There isn't a whole lot of room for kind of cultural fit or being sort of close to the ground. But I'll leave that for another conversation. But I think it's the more one reads the book, the more one realizes that, you know, some of the implications are potentially really eye-opening and quite radical. So because I only have 5 minutes, I'll ask just maybe a final question. You know, my understanding is you probably one of my colleagues who's best used one of his sabbaticals, so that you used an entire sabbatical to actually go in the field, as it were, and could you tell us, and you know, I often advise grad students, I mean, I tell grad students, we should be doing more of it, right? And even as very few of us do it. Can you maybe enlighten us about some of the challenges that you faced or things that you might have done differently, knowing what you know now?
Well, the first thing to say is that field work is fun.
Right.
And after, you know, 25 years of sitting in my office, you know, thinking of stuff and writing them down, actually going and talking to people and seeing places and listening to what the concerns are that animate a legal issue was really kind of an eye-opening process. It is at the same time extremely challenging because what you find, what you hear is super interesting, but what the hell do you do with it? You know, okay, so I have interviews. It's not so easy to figure out, you know, how to use interviews in legal analysis. And this is something that, you know, other disciplines like anthropology have, they have boxes, you know, in your little insert box. But this is, you know, the general anthropological narrative is mostly descriptive and perhaps analytical, but not in a normative sense. And in law, we try to offer legal analysis. So everything you put on the page should serve a purpose other than to entertain. And that's an enormous challenge, is to know how to use the stuff. You know, a million tidbits that have to be put together in some ways that advance the thinking. And that really, you know, if you put a quotation from an interview from field work between two paragraphs, really the paragraph after the quotation should be understood differently because you've read what this person in, you know, northern Iraq had to say about the Islamic State justice. So that's one thing. What would I do differently? It depends what kind of work. I mean, this was work, and you talk about danger. I'm, you know, I don't want to overstate that. There are places I did not go to, like Afghanistan, because it was more than I could manage as a one-person operation. And indeed, one of the most difficult things that I found in doing this was figuring out where I could go. And it's really very, very hard from, you know, thousands of kilometers away to figure out, you know, can you actually go to, you know, like today, you know, go to Kabul. Okay, well, you know, there are journalists in Kabul from Western media outfits, so it's not completely crazy, but probably is completely crazy to think that you could go. But this is an example of, you know, okay, so who do you ask? You know, who has these answers? It's very hard to figure out, but it's an absolutely critical thing, because when I read some of the stuff, a description of what graduate students did, you know, doing field work in, you know, around Goma in Eastern Congo, I really, really worry, because it's a very dangerous place with completely unpredictable patterns of violence. But there are people everywhere. So the fact that some people are there, for me, was not good enough. So it's an extraordinarily delicate and difficult balancing act that you must do.
Yeah, and as I was listening to you, I was thinking also the challenge of how you're perceived. I mean, what is that curiosity from a Canadian academic, you know, what does it portend? How is it interpreted? Is it welcome? Are they kind of, you know, honored that someone is finally paying attention to the good work that rebel courts have been doing, or you know, on the contrary, you know, you identify as a spy? That's not a question because I've already asked my final question. It's a comment. Réne, really, thanks so much for indulging me with all these questions. As you can guess, I have another 12, but I'll ask them at dinner time, sit, you know, at a safe distance from me. So, and we're now taking questions from the floor. So, Catherine.
Wow, that was quick. Thank you. Thank you so much. That was such a delightful conversation. And Réne, I'm obviously, that page turner idea got me. I want to figure out what the twist is, and I'm going to get the book very, very soon. So congratulations. I had two comments. So one was on the witch question. I thought that was very interesting that, you know, that there are courts that try to regulate witchcraft. And it reminded me of Hobbes's Leviathan, in which he does talk about how witches, you know, should be punished or at least outlawed, because not because he thought they were really witches, but because, you know, he thought they pretended to be supernatural forces, which, you know, obviously would make people do things that were not in their Hobbesian interest. So I think even if you look at the history of, you know, sovereignty, this idea of the sovereign as the great definer, including of witchcraft, is quite, you know, embedded already historically. But my question has to do with something that you guys talked about with respect to Clausewitz and how, you know, war is politics by other means. And I think Frederick was giving us this impression that by looking at rebel courts, you were trying to show that in some ways they share similarities with, you know, state courts and therefore are perhaps not as illegitimate as a state-centric view of law or international law ought to presume. But I thought another effect, and I wondered whether you thought about this intentionally or not, is it could also serve as a deflationary view of law. I think that Frederick, in a way, was moving towards this idea, in the sense that, you know, to show the similarities is also to show in what way state courts themselves are also, as you say, you know, sources of coercion, of domination, and really are about power, right? So it's about the connection between law and politics. And so in a way, you know, one could one read your book and say, yeah, you know, they are similar, and therefore, you know, we should understand law as always a form of politics, and in a way as about power, you know, power to define, power to judge, power to execute. And if we have trouble with rebel courts, of course, we should also have similar problems with courts in general. Is that something you intended, or is yeah? I'm trying to figure out.
Yeah. Thank you. Maybe just one comment about witchcraft, just to say that it actually begs the question of why do we not talk about witchcraft in Western, right? And it's something to do with kind of the empire rationality, and that we, you know, it doesn't fit in our model of how we think, how we behave, how we relate to each other in ways that, of course, in different places in other parts of the world, they think completely differently, and there is often a clash between state court and local ways of thinking that's much more significant than there is here today, but perhaps that there was when Hobbes was writing.
Except during Halloween.
Except at Halloween, yes. Otherwise, yes, indeed, the critique of rebel courts is in some ways the critique of any courts. And the idea of the administration of justice is a pluralistic one. And it's not because we call state courts in every country that they really are all the same thing and correspond to the same concept. Just like, you know, the rule of law, you know, China has its rule of law with socialist characteristics that turn out to be significantly different than the rule of law without socialist characteristics. And so we, you know, courts there are different, for example, than they are here. One difference that is perhaps more systemic between state courts and rebel courts is place that they occupy within the general kind of endeavor to govern. if I could put it that way. And this is connected through a very kind of technical, legal requirement for the application of international humanitarian law, which requires that an act have a nexus to the conflict in order to be regulated by humanitarian law. Because humanitarian law applies in wartime, but is not meant to displace all other laws. A regular law is supposed to continue applying such that if you steal your neighbor's cow, or if there's a fight in a bar on the basis of a pool game that went bad, IHL, humanitarian law, doesn't really have anything to do with that because there isn't a nexus to the conflict. My impression is that rebel courts are so tied to the insurgency that everything rebel courts do has a nexus to the conflict. And I claim that the theft of the cow is also regulated by international humanitarian law, which is, there's a kind of an arcane, more technical debate for experts, some of whom disagree with me, but there's a broader point that speaks to your comment about how we think about courts and whether we're always thinking about the same thing. And I think that the answer would be no for me, that there are variations that are significant in what we are thinking about.
Good. Thank you, Professor Provost. Thank you. I haven't read the book, but I have it there as a part of my reading list. But I have two questions, very concrete questions, maybe too practical. But one is, I read your article about FARC justice, 2018, and there you made reference to some elements that a rebel court should integrate to be considered at least a court. So minimum elements. And one of them is fairness, certain degree of fairness that they should apply when rendering decisions. But you said that that was not the moment of the space to get into the details of what the content of the due process guarantee should entail in those type of proceedings. I was wondering whether in this book you get into that and you analyze in detail that element of due process guarantee by a rebel court. And the other question is also related to something that you said that usually like rebel governance emerges for practice within the ranks of the armed groups, and they just extended it and they can adapt it to the particular countries where they are. And in Colombia now we are having this situation where former combatants are coming to ordinary courts and saying what they did to me, the sanction they imposed, what they did to a relative of mine who was a member of the armed group, I consider that was a violation of human rights or a violation of the IHL. And IHL allows for armed groups also to have their discipline, rules of discipline to provide to their members. And I was wondering if you have thought or you discussed the legitimacy of a state-established courts to pass judgment or analyze the decisions made by rebel courts with respect to their members, to their ranks.
Both really excellent questions, and there are some answers in the book. As to the first, due process is an idea that is central to the notion of the administration of justice, and I think I talk about it as part of the idea of the rule of law, is that these rules be applied fairly, because if they're always applied, systematically unfairly, it's not really compatible with the idea of the rule of law. That's expressed at a general level. Of course, international human rights law has translated this into a lot more specific requirements of due process. And I thought that it was very important for me to try to tackle this head on, because often people will say, well, maybe they, of course, but they're always unfair, right? It's kind of a presumption that, yeah, ISIS court, yeah, right. And in that particular case, perhaps that is true. For the FARC, not so obviously so. And in many ways, the encounter of rebel justice with due process guarantees, which are essentially from human rights law rather than from humanitarian law, going back to this interface between the two fields. In many ways, this is where the rubber hits the road, where, I thought, okay, I have to work my way through these sort of technical requirements of procedural justice and figure out what do they mean before a rebel court, and am I going to conclude that where there's in fact no way a rebel court could meet those requirements, and therefore the whole thing would have been a bit pointless. But in fact, what I find is that there is a need to adapt these requirements to the reality of courts operating in zones of conflict on the one hand, and courts that are emanations of non-state actors on the other hand. And both these are elements that are already recognized in international law as relevant factors to take into consideration when applying human rights law standards like due process guarantees. So, for example, in human rights law, there is a right to a public trial. Okay, this is a fundamental right. It is a right that, when we apply it to rebel courts, becomes transformed by the fact that for armed groups, including rebel courts, visibility is a factor of vulnerability. And for example, in Afghanistan, Taliban judges were ranked as high-value targets by the coalition authorities. And so that had an impact on the possibility of a public trial, because, of course, it would have been to invite a strike by coalition forces. So this is one example of a way in which the fact that we have a standard that is applicable to both will have to translate into something different, right? And the requirements of publicity for state courts in peacetime have to be adapted to the reasonable expectation of security that both the judges and parties would have by participating in a court. The second point is to say, is to indeed, we can look at this kind of as a closed circuit, and asking, well, what are rebels doing, and these courts, and what do they do, how they operate. But I think an important question is the second one you asked, which is to inquire into the rayonnement, the reverberation of this action, including the recognition by other kinds of actors of what these courts do. And in the final chapter, I do look at kind of recognition by international tribunals like the International Criminal Court and the European Court of Human Rights, recognition by third states, going back once more to Omar Sakan, Sweden, through its court, had to decide what was their position vis-a-vis the courts of the Free Syrian Army. So they were confronted with a duty to give a very definite answer, yes or no. Is this lawful? Not just the establishment of the court, but the sanction that was imposed. Then there's the possibility, and this is the example you gave, of recognition by the very state against which the insurgents are fighting. And this, sounds crazy. It's like, yeah, right. The current government is going to recognize, decisions of FARC courts. And the answers are more ambivalent. And I have there's an interesting precedent related to the United States and what the United States Supreme Court did about decisions of Confederate courts during the years of the Confederacy, where thousands and thousands of decisions were issued. And the Supreme Court, after an initial, very stark rejection that this was all illegal, realized that, well, actually, this was not viable legally to just ignore what had happened during these years of the Confederacy. And so they modulated very significantly their position. And we see it in Colombia. Sometimes the FARC would write their decisions into the official records of the local authorities, where decisions of popular assemblies would be written, where the FARC would write their own decisions in there too, and so they get inserted into the official legal system in ways that are invisible to the state. And the final example is in Sri Lanka, when I asked lawyers in Colombo, I said, what happened to, for years, they said they decided over 30,000 cases before the LTTE courts. And, it's cases about, disputes about property, and one gets decided that then it gets sold 7 times. After that, and what, you're going to go back, and it makes no sense, right? People divorce, they adopt children or whatever. You can't undo all of that. So I said, surely something is going to happen. And I was met with incredulous looks saying, well, obviously it's nothing. But then when I went to Jaffna in the Tamil region, I talked to lawyers there, they said, oh yeah, you can actually submit judgments from the LTTE courts as evidence before the courts of Sri Lanka, and they will take into consideration. And I got one judgment that was an example of that someone found for me, which is absolutely extraordinary. And I don't think that the Supreme Court in Colombo knows about this, because there's a language barrier. The Sinhalese, on the whole, don't read Tamil, and if it's written in Tamil, they probably won't have access to it. And there are really not much appeals from the Northeast to the Supreme Court in Colombo. So it happens mostly in surreptitious ways on a continuous basis. And sometimes at the end of the war, there are processes that can also happen when one armed group recognizes the legal acts of another armed group. And this I saw in northern Iraq, where the Kurds have a process for giving legal recognitions to legal acts of ISIS, of Islamic State courts that people have. And then they can go and get it, basically validated for the Kurdish authorities, which in turn will not be recognized by the central Iraqi authorities. That's another process of recognition that has to take place.
I'm going to jump in because there's a question from the online, but along those lines. I just want to underline, it really is testimony to the breadth of the book, but in an hour before, we didn't even reach that whole chapter that you've written on the as you were asking, have you worked on this? Well, like, yes, he has. It's like it's 50 pages of it. It's very dense. It's very well written. There's just a really interesting kind of almost private international law component. I'm reminded that the issue arose with Nazi courts as well, and sort of private law decisions. So Jack Nelson online here says, or I'm just going to sum up that the question has arisen in relation in Hong Kong, for example, in relation to recognition of court decisions in Taiwan, and on one level, well, this is completely beyond the pale, and on another level, there's just the strength, right, of the effectivity of these decisions and the sheer disruption that would come from ignoring them. So, and I think you actually mentioned that as a sort of telling example. So that was from Jack. Alex.
Merci. Thank you so much. It was the conversation is very, very inspiring. Maybe to generalize a little bit on your last comments and go back to the beginning when we were talking about the rule of law. So I was thinking, so all the description that you gave of recognition of each other's judgments and the reality on the ground. So there's an aspect of effective administration of justice, and then you cannot just redo everything that has been done. So there's an aspect there of sort of a sociology of law, type of the law is happening on the ground. But I was wondering, when you get to the end of the process, what's the, going back to the title of your book, so it's not alternative courts, it's like rebel courts. So we could imagine doing that sociology, you could do another book on rebel post office service and rebel public transportation, and so it's the administration of territories and things that IHL sort of says that occupying powers have to do, so even though there's a war, life has to continue. But here we have rebel courts, so you touched on that. The question is courts that are linked to a rebellion. So there's a war going on. And I think you mentioned it, the fact that eventually everything is connected to the war. So the court activity is connected to the war, like public transportation and the post office would be connected to the war. And so when we think about courts, I think in the general model of courts, we think of courts in the separation of powers. So there's, some legislatures, some government of some sort. I don't know if it's applicable, this can replicate that to the alternative universe of these, rebellious movements. But in terms of, from your, so conceptually, there's a question of, what's the rule of law in that universe? But from your sort of engagement with what's going on in the field, is it possible to disengage those court activities from the war? Is it not, at the end of the day, that the court activity, even with contracts, even the cow situation, ultimately the activity, the judicial activity is contaminated by the fact that there's a war going on, and at a certain level, everybody's involved in the war. So at the end of the day, when you take all those decisions and you say, this is effective law that has happened, and then you have to continue on, what happens in terms of legitimation, normalization of the war? So we don't go back to the fact that the decision about the cow, the decision about the water, about the neighbors, everything was contaminated by the fact that it was a war. But then we just say, no, it's just, it's law. It's just an alternative. So there's the normative aspect of, it was a different kind of rule of law, so a different kind of universe. So how do you get back to that, the fact that they are rebel courts, so they're like political, it's like this paradox in the title. It's like the political sort of label attached to a judicial organ.
Right. So, yeah, wars happen and can't be undone. And we have this phenomenon, in other conflictual settings. I think Fred mentioned earlier the, post-Nazi Germany quandary of what to do with 12 years of Nazi administration of justice. And so part of the famous portfolio debate is about one such case. But this was a highly unusual case in the sense that it went back. To look at it, overwhelmingly, nobody went back. And there was a strong continuity in the law being applied that was matched by the continuity in the judiciary. That, at the beginning of Nazi Germany, Jewish judges and lawyers were expelled. But apart from that, there's pretty strong continuity throughout and after the war still, which is matched in the law, and you can't undo it, right? So, all these buildings in the Marais that were dispossessed during the German occupation, mostly this was not undone after the war. I mean, some was, and a lot was not. And the same obtains for places which are under the governance of rebels. You simply cannot undo years of daily decision-making and life occurring. Now, another part of your question is about sort of the rebel dimension of all of this. And of course, you won the war, that should inform the way in which you address what the rebels did. And we don't tend to give longer life to public decisions of the defeated rebels after the end of the conflict. But I think law is a funny dynamics in that respect, in that it doesn't tend to be punctual, but are decisions that are inserted in a continuum, so that you can't return. But that, despite the fact that rebel courts indeed are a part of the rebellion, and there's a question of whether that is problematic from the point of view not just of the rule of law, but also of a certain sense that judicial independence is part of the idea of what a court is, and that if an entity, a decision maker, is not independent, then that we don't really have a court. And what does that mean for a Taliban judge? It's like, really independence? Like people start smiling when I start saying things like that, because it seems just ridiculous. But the reality is a lot more complicated. So the rebel courts are part of the insurgency, just like state courts are part of the state. That doesn't mean they're not independent, right? They're all informed by the Constitution and other things, and we don't have a problem with that. That, Canadian courts, well, they're bound by the state constitution. Yeah, right. They're a state entity. They are a political body in that sense. They are there to enforce a particular kind of political program. So why can't we do the same thing for the Taliban courts? Of course, they're part of the Taliban, just like the state courts are part of the state. And so we need to kind of separate these things to try to identify, what is the problem. And the problem is more about a degree of autonomy rather than an alignment with the values and objectives of the insurgency that might inform what the court does, just like it does for courts. And for me, I was more interested in, could Taliban judges or even ISIS judges decide in a way that was autonomous? And the distinction, the difference is quite interesting. So ISIS judges were often punished for not having given the good decision. And so there was a sense that judicial independence and the very idea of the rule of law was rejected by ISIS as a kind of a Western invention that they wanted nothing to do with. The Taliban, on the other hand, had all sorts of mechanisms to, for example, prevent local commanders from influencing the decision of judges. They had a strict system of rotation of judges, where judges moved from province to province, not including the region where they were from, so that they would never be progressively co-opted by local dynamics and so on and so forth. And so it's kind of surprising, amazing in many ways to discover that. But, and it doesn't mean that Taliban justice was wonderful, and no, Taliban justice is awful in other ways, but not necessarily in every way, and not in the way that you were pointing at, which was kind of this. It's just a part of. It's like a part of the insurgency. You might as well give them a gun and get them to shoot the parties. That's the same thing. And I don't think so.
Okay, one final question, Richard. I'm mindful that time is almost up. So.
Oh, goodness. Well, congratulations on this magnificent achievement. I'm anxious to start turning the pages. You made an allusion to Robert Cover and this fascinating observation that the rebel courts might be a kind of laboratory for studying a specific kind of relationship between violence and the law. And I wondered if you had comments about, I'm thinking of Walter Benjamin and the idea of a kind of law generating violence, which is associated with a certain moment of the emergence of law. In what sense were the rebels that you studied, in fact, seeking to be law generative, not only in the deployment of courts, but even in some sense in the insurgency itself?
It's enormously variable. And so there isn't one model, and there are many insurgents that simply take a body of law that was pre-existing. And, you know, ISIS, the Taliban largely claim to take a particular interpretation of Sharia and apply it in as faithful a way as possible. And so they, you know, it would be anathema to their credo to claim to make law, right? It goes with the territory, you might say. And the FARC, to a large extent, you know, they wove together, they kind of braided their program and their priorities and their needs into local ways of doing things. And they had a document called Manual de Convivencia, so manual for living together, literally. And it kind of connected all sorts of things that a lot of people recognize. On the other hand, the LTTE enacted its own LTTE civil code, LTTE criminal code, LTTE code of criminal procedure, code of civil procedure, Chapter Second Act, you know, and on and on. Again, kind of mimicking state lawmaking processes. Of course, all of this is a way of getting back to Kava's insight that, as he put it, judges are people of violence. They do not make law, they kill it. This is a quote from Kava. And in the sense that this is a kind of epistemic violence where you use power to displace one way of thinking about things by another way of thinking about things. And that is kind of an imposition through force that is violence. So certainly rebels are doing that. Are they doing that in ways that are so different from the state? I mean, the shift might be more sudden, but in its essence, I think it's the same thing.
Thank you very much, René. There was one final question on Zoom, which I mentioned. You don't have to give an answer, but as you know, many of us, as the minute we send the manuscript to a publisher, you know, realize we've forgotten something significant. So the question was, you know, what would that thing have been from Maria Rodriguez? If you could go back, apart from a couple of typos.
Yeah, I was going to say there's that typo at page 397 that you pointed out. Honestly, I'll be honest. I put everything in this book. Sometimes literally, that's why it's so long. But I've said to some people, it felt like another PhD thesis, 25 years after the first one, after swearing I would never do another thesis. So there it is. So no, I did actually, I put everything in there, and or I'm still in a state of denial that there was anything else to say. So I don't have anything.
René, that's great. And honestly, I think that's the mark of a major work, that you, at least for some time, you know, you can sort of suspend your frustration about it. And I had the same impression. I would have struggled to know what else could have been added. I just want to finish by saying that there's a word that came up in just now and that comes up again and again in the book, which is braiding. And I cannot help but notice the obvious echo that the word has in this context. So to go back to this idea of being both rooted and nomadic, and to sort of go around, you know, pour tel Ulysse, revenir à la faculté, revenir ici sur ces terres avec ce message de toute cette richesse. René, du fond du cœur et de la part de nous tous, merci de ta patience et de ta volonté de répondre à nos questions. Et I obviously strongly encourage people to get the copy, which is available electronically, I should mention, at the McGill Library already. And please join me to thank René.